and welcome back to a new season of Startups Streamlined with us here at Thompson Hine. I'm Lindsay Stencel. I'm a partner in the New Ventures Practice Group, and we have a great lineup of topics this year. So this is just the first of many where we're talking about one of the most important assets that any company has, its people and its teams. And so once again, we are joined by Anthony McNamara. He is a senior associate out of our Cincinnati office, and he is one of my go-tos for all things employment-related issues. And he's in our labor and employment practice group primarily. So there's a lot of things he's seen and a lot of stories that he can certainly tell us and great advice that he can provide. Today, we're going to discuss why it's important for business owners to weigh several factors when establishing their startups, their businesses, including their legal obligations as an employer. During the discussion, we'll explore the possibility of the FTC, Federal Trade Commission, eliminating non-competes altogether. And compliance with wage and hour laws, maintaining personnel records, best practices for communicating with employees, and of course, using severance agreements, because sometimes you just got to break up with folks. So if you have any questions or comments along the way, drop those in the chat. We're monitoring that as we go through. If there's any questions that remain unanswered, we'll reach out to you separately after we get started here today. But without further ado, Anthony, welcome to the first of this year's Startup Streamlined series.
Thanks so much, Lindsay. I'm glad to be back and glad to be chatting with you again.
Yeah, same thing. So, naturally, there's always way more to discuss when it comes to labor and employment related issues than we ever have to cover in a 30-minute session here today. But one of the things I was hoping we could just touch base on is like a level set and a reminder. Could you just walk us through the differential between employees and contractors to level set for folks, and what are the things people need to be thinking about there?
Absolutely. And this is, one of the main questions that I get and one of the main issues that we see. And by the way, not just for startups and small companies, but companies of all shapes and sizes, is how do we classify our workers, right? When we're dealing with employees, we have, certain obligations to them under various employment laws and tax laws that may not apply if somebody is indeed a contractor. But whether somebody's a contractor is very limited in scope, and it really comes down to who has the right to control the work and the means and methods by which the work is done. Is the employer setting the hours? Is the employer providing the equipment that the individual needs to perform the work? Is the individual required to come into the office? Does the individual have, any prospect for profit and loss based on the type of work they do or the amount of work they do? Can they do the same type of work for other people? Are they holding themselves out as an independent business owner? These are the types of factors that courts and agencies are going to look at to figure out if somebody is indeed an independent contractor. Just having a contract in place is not the end all be all. It's really going to come down to the person's job duties. And unfortunately, oftentimes we are seeing, misclassification happen, and there can be a lot of consequences for that. For instance, if the employee should be not exempt from overtime laws, right? If they should be paid overtime for their work and you are not providing that, there are some significant back wage and liquidated damages penalties there. But in addition, you've got tax penalties because you've not been withholding taxes. So this is a very important analysis that all employers should be doing at the outset of any employment arrangement to figure out which way to go.
Yeah, and it's probably important to note that it's different from state to state.
Correct.
Right.
Yes, we've got our very employee-friendly states, the Californias, the Massachusettses, the Illinois of the world, and some that we'd consider more employer-friendly I will say that we are seeing, a little more pushback across the country on how we define independent contractors, but there are some states that would follow the ABC test, which is much more employee friendly, and will simply look at, can this person do this job for other people? Are they doing something that you have other employees doing? Others that really focus on 10 or 20 factor tests. All of them, though, come back to who has the right to control.
Sure. Yeah, so I think it goes without saying, if you have workers in multiple states, it makes sense before you start engaging with them to make sure that they're classified appropriately, because to Anthony's point, it can be pretty expensive if they are not. So let's continue down the pathway of dollars. So let's talk a little bit about compliance with wage and hour laws. I feel like this is one of those topics where a lot of clients go, well, I'm paying this person a salary and maybe they have a little bit of equity, so I feel like their salary is fine, even though they work 80 hours a week. Let's talk about why that may or may not be right.
Right. Paying someone a salary does not automatically exempt them from overtime laws. When we, with our clients, we mostly are seeing what we call the white collar exemptions, your administrative employees, your professional employees, and your managerial and executive employees. Salary is one of two components to determining whether or not somebody's exempt from overtime requirements through those types of jobs. There's also a job duties requirement. If they're an administrative employee, are they performing non-manual work that is central to the employer's general business operations, and are they exercising discretion and independent judgment with respect to matters of significance, right? So your secretary, probably is not going to be an exempt professional. An engineer, probably is, depending on the job. So when we're looking at, should somebody be paid overtime, we want to make sure that we understand not only how the employer plans to pay them, but what is this employee's role going to be? Are they a salesperson? Are they, going to be a manager? If they're not going to be actually overseeing someone, do they have significant input into personnel decision making and providing recommendations on that front? These auditing these jobs from the outset can save you a lot of headache down the line.
Amen. Yeah, because again, that one gets pretty expensive when done incorrectly. There's a theme here. When we are wrong, it costs money, a lot of money. You have to pay attorneys, you have to pay tax folks, you have to pay the tax person, however we want to qualify them. So it is never cheap, and of course never fun to be dealing with. So, all right, let's continue down the line here. So let's talk next a little bit about the concept of maintaining employee records. What's the best practice here? How long should we be thinking about doing this? How long are we able to do this? Let's just dig into that for a moment.
Sure. I litigate probably about half the time in my practice, and so I look at my compliance practice from a litigator's lens. Sure. Having documentation is far and away the best defense that any employer can have to a claim of wrongful termination or discrimination or failing to accommodate a disability or a religious belief or practice. Any employment lawsuit that you can think of, having documentation in place and having a practice of maintaining that documentation will go so far in helping you be able to defend yourself. You had asked, Lindsay, how long do we keep these documents? And to give you the lawyer answer, it depends. It always depends. It's going to depend on the type of document, as to how long state or federal law may require that it be maintained. I would say the general rule is that the longest any document is typically required to be maintained is 7 years. Now, do you want to be keeping every personnel record that you have for a period of 7 years? Maybe not. It is important to maybe have some different records retention policies in place. Wage records are generally required for 3 years. Hiring documents for 1 year. Personnel files, benefits records can be, I believe, 6 years. So there are different time periods, and so there's multiple ways that we can go about preserving, those records so our employers aren't inundated with paper.
Sure.
In terms of what should we be documenting, when I look at this, I think the prime example is discipline and termination. Unfortunately, these things happen from time to time, and rarely will an employee think that they've done something wrong or that the discipline or the termination was justified. Having a practice of maintaining disciplinary documentation and termination documentation can go a far way to helping you defend these types of claims. That does not mean that every employee is entitled to progressive discipline, right? That they would get a verbal warning, 1 or 2 written warnings, and then termination. Obviously, employers maintain the discretion to, enact the correct discipline based on the infraction involved. But if you have a chronic poor performer, having documents in place that show that you tried to coach, that perhaps you put them on a performance improvement plan that had clear objective measures for how they could get off of that plan, notification that any further infractions will result in further discipline or termination. These types of things, even though we generally live in an at-will employment world, will provide you with the defense that you need if you need to justify any termination in court or before an agency.
Interesting. Okay. So everyone just loved to hear about that and
Yes.
all of the records they get to retain. Now, hopefully most of those are digitized these days, so that's a little bit simpler than storing them in the old-fashioned multi-tier filing systems. I'm old enough to remember those being all over offices everywhere. One thing I don't think you and I prepped about too much, but I think it's important to bring up because there was a lawyer in a firm out of Cleveland who sort of stirred the pot here. But can we talk about maternity leave and paternity leave for a moment and what people are entitled to, and maybe some pro tips about what people should and should not say to people while they're on maternity or paternity leave?
Right. And for those who may not know what Lindsay's referring to, there was a attorney out of Cleveland who texted a female colleague of his while she was on maternity leave, and after she provided notice that she was joining a new job, to really say some nasty things,
Sure.
things that I'm quite embarrassed that somebody would say, but really chastising her for making that decision and quote unquote, receiving pay while quote unquote sitting on her rear end. And these things are not acceptable in any form or fashion in the legal realm, in any realm. But I just wanted to say that quick. Getting to your question, Lindsay, whether there is the rights that we may have for paternity and maternity leave will vary based on state and what's required, and employer size. We do have the Family and Medical Leave Act, which generally only applies to employers with over 50 or more employees, and there are some other eligibility requirements there. It's quite a tricky law, but that would provide 12 weeks of unpaid leave. It generally doesn't apply to pregnancy, though. But there may be disability leave policies that an employer may have. There are a lot of states now, and the recent trend is to provide more paid family leave, paid parental leave, and even where states are not requiring it, we are seeing more and more employers provide it because it is such an important aspect of workers' lives, right? And so that's what I'll say is really it depends. We are seeing some movement at the federal level with more pregnancy discrimination protections, not necessarily leave, but the obligation to accommodate pregnant workers and workers that have just given childbirth, which does tend to not fall under the ADA, but now will fall under different pregnancy-related legislation. But, you know, employers should be accommodating. You know, one you said at the beginning of this talk, Lindsay, was employees are our greatest assets, and they are. And if employers want to be retaining top talent, you know, leave is something that they should be considering providing, both to mothers and to fathers. Giving birth is not something that somebody can quickly come back to right away. So, you know, and then in terms of what should happen while someone's on leave, you know, make sure that you're working with the employee while they're on leave to understand when they anticipate coming back. Sometimes employers can consider ramp-up schedules, you know, not bringing somebody back to work at 40 hours a week right away, you know, providing some part-time hours at first. Understanding that flexibility in the workplace is going to be a big thing. Finding childcare is not always easy for young parents.
No.
Doctor's appointments come up. Kids who are awake through the night or who get sick and require emergency doctor's visits. Maintaining flexibility with your employees is key. And while they're on leave, understanding that they're not supposed to be working, and trying not to bother them, but also making sure that you're working with them before they go on leave to ensure that work has been diverted to where it needs to go, and that they're able to go on leave with nothing left on their plate.
Yeah. Yeah. And I think that's one of the things I see a lot of people make the mistake about, even though someone's on leave, you know, someone gets contacted, and that is a big no-no. Do not do that.
Right.
So anyway, great feedback there. So let's talk a couple things here. What are some best practices generally in communicating with clients? I know we kind of talked a little bit there about retention policy, but before the retention policy on the documents of maybe a troublesome employee, we probably need to have some level of communication with them about what's going on. So let's talk a little bit about that for a moment.
You know, and that's a great point, Lindsay. You know, I encourage my clients to be forthright with their employees. You know, sugarcoating never benefits anyone. If you have to have a serious conversation with an employee about violation of work policy or poor performance, you're placing them on a performance improvement plan, et cetera, be direct. Talk to the employee. Help them to understand what the issue is, why we've gotten to this place, and what needs to happen moving forward. You know, we want to make sure that we are setting clear expectations, both verbally and in writing. The discipline conversation, the termination conversation doesn't have to be a forum, a place for, you know, receiving challenges or a place for receiving question and debate. You know, you as the employer have the authority to make the decision, and really you're just communicating that to the employee. So be forthright. Be objective to the best you can, and you know, I hear a lot of clients say, you know, well, you know, they're an at-will employee. You know, I can terminate them for any reason. Do I have to give them a reason why I'm letting them go? From my perspective, yes, you do. And the reason is, when you don't, you're letting the employee come up in their mind with what the reason might be. It might be, you know, their gender, their race, they have a disability, they recently expressed concerns about safety issues in the facility. Whatever it may be, if you are not setting the record straight, you're allowing them to come up with the reason on their own. Now, does that mean that they, you know, won't come back with a lawsuit or with an attorney later on? Maybe not. You know, they maybe still will, but you've at least informed them of the reason, as opposed to telling them no reason, which then you have to explain later on, perhaps to a jury, why you got cagey.
Yeah, and that's never a great place to
No.
be. So great. No, that's super helpful. Um, and then along those lines, sometimes we just got to break up with folks. And so let's talk about severance agreements for a moment here. What do you think about when working with clients and getting severance agreements in front of employees?
Well, the first question I always ask, and as you know, Lindsay, is are you planning to pay severance? And I think, you know, severance should always be a consideration. I'm not saying you always have to provide it, but it has a lot of benefits. It truly does end the relationship between you and the employee. It avoids the possibility of headaches down the line, and it helps to sort of smooth out the impact the employee may have from the news of termination, right? You know, here's some extra funds that'll sort of help you get by while you get on your feet, and as a way of breaking up. Of course, this isn't always appropriate. If somebody, you know, really has done something egregious, maybe we don't want to give them severance, or they haven't been around a long time, or it's really not our policy to give severance. I understand there are reasons that clients may not want to, but it should be a consideration. When we are talking about what should go into a severance agreement, you know, certainly we want to make sure we understand first and foremost whether the individual is over the age of 40 or under the age of 40. And the reason we want to do that is in order to validly release age discrimination claims under federal law, individuals over the age of 40 need to be provided with certain disclosures and certain protections. The release of such claims has to be clear and conspicuous. They have to be given at least 21 days to consider the agreement and at least 7 days after signing it to be able to revoke that agreement. They have to be advised in writing of their right to consult with an attorney. And if they are part of a larger separation, a reduction in force, they need to be provided at least 45 days to consider the agreement and some disclosures of who else was part of the quote unquote program, the group of individuals who were, you know, looked at for either selection for termination or not. So really it's all about providing them with a lot of information, with enough information that they can make an informed decision about whether or not to sign the severance agreement. Unfortunately, if you don't provide these, you know, you're paying severance, you're getting a release of other types of claims, but not age discrimination claims, which can certainly come back and bite. You know, there's other things we want to consider. You know, how, if there are other agreements that you have in place with the employee, how are they going to interact with the severance agreement? Restrictive covenant agreements, non-competes, non-solicits, and I know we'll get to those in a bit.
Yeah.
You know, non-disclosure and confidentiality agreements. Does the employee have any contractual right to equity in the company? How are we addressing that at the separation of termination? Can we? You want to make sure that you've got an employment attorney and possibly a benefits attorney taking a look at these issues.
Yeah, it's a lot to consider. And so I noticed you said over 40. Does that include people who are 40, or is it 40 and like over 40, so 41 years old and up?
Great distinction. It is 40 and over. So you know, I misspoke, but it is, you know, if somebody's at the age of 40 or over, they are protected under the ADEA. Yeah.
So level 4 and higher.
Right.
If you are level 4 and higher, you are protected. Excellent. Okay, so this is the topic that I'm like really excited to talk about, just because I'm sort of like nerding out conceptually on what might happen here. But first, can we talk about non-competes? Like, let's just talk about them in the state of Ohio, because again, non-compete law is governed on a state-by-state basis, but also has a federal overlay, if you will. And so can we talk about what actually that means and what has to be included in a binding non-compete? Because I see a lot of these that are like, it's worldwide, including Mars, and it's into perpetuity, and it's for someone to style hair. Like, that seems crazy that would stand. So talk to us about what those look like, and then we'll dive into what the FTC is talking about here.
Sure. As you said, non-competes, they're contracts, right? This is an agreement not to compete with your current employer, either or both during your employment and after for either a certain period of time, or some folks try to do it in perpetuity. But it is a creature of contract. It is governed by state law for the most part, and each state has their own requirements. Here in Ohio, it really is just it has to be a reasonable restriction and aimed at protecting against unfair competition, but not something that's going to harm the employee's ability to make a living in the future. What is reasonable? That really depends on which judge you have who's trying to enforce it.
Sure.
Generally speaking, restrictions of up to 2 years are typically deemed reasonable. Geographically, it may depend on your industry. If you are in a niche industry, you have very few competitors, across the globe. A worldwide restriction or a nationwide restriction may work. If you are one of, 20 different shops of your kind within your city, you may be looking more at a 10-mile radius, a 20-mile radius, 50, so on.
Mhm.
It really requires looking at what what you do as a company and what your industry does. Oftentimes, though, we do see companies that want to say this is a 5-year non-compete. It applies across the country, even though you employee are a fairly low-wage worker. But the conversation I'm typically having with our clients is, why do we need this? What is this person? What's the risk of them competing with you down the line?
Yeah.
What can they do? What can't they do? And what do we think could plausibly hold up in court? And so these are the types of things we ask to try and figure out what is reasonable.
Yeah. And so let's talk for a moment because we have about 3 minutes left. But the FTC has entered the chat and they have said maybe non-competes aren't reasonable for anyone. And I think part of what's driving this is, to your point earlier, of this has been handed out to every worker across the board. Doesn't matter where they sit. And if you want people to be able to be employed and not being forced to either take unemployment or somehow go back to school to get a totally different degree, you have to allow people to work. And so I think the pendulum has probably arguably swung too far on the non-compete side. So let's talk really briefly about how the FTC is starting to think about this.
Yeah, and I agree with you, Lindsay, and that's where the FTC's come down. So as background for everyone, about a year and a half ago, President Biden, instructed the FTC to begin looking at possible rules, for restricting the use of non-competition agreements, what we're talking about here. We hadn't heard anything, since that directive was issued until January 5th, and the FTC decided to start 2023 off with a bang. What they've done is they've issued, for those of us who've gone to law school, we probably all avoided administrative law as an elective. I know I did. But what the FTC issued as a federal agency is what's called a notice of proposed rulemaking. And it really is, here's what we're thinking of doing. We would like the industry to comment. And what they have proposed is a universal ban on all non-competition agreements. And I'll say two things about that. First, where they've come down on it is kind of what you said, Lindsay. These have gotten far out of control. They're used far more often than maybe they were intended to be. It's resulting in, wage stagnation and an inability to truly innovate in the market. Look at California, for example, who bans non-competes, now has Silicon Valley, right? That's where the FTC is looking. They have said, we would like to ban all non-competes without exception, right? So no exceptions for your highly compensated workers, research scientists, et cetera, or other restrictive covenants that, in effect, act as a non-compete agreement. So could be your non-solicitations, your non-disclosures, et cetera, depending on how they operate.
Mm-hmm.
The public has 60 days to comment, after which the FTC will come out with its final rule. I think there's 180 days after that's issued before it would go into effect.
Sure.
You know, and we do expect there's probably going to be some form of the rule enacted this year. But we also expect that there will be some industry groups that will file litigation to try and block it. So we don't really know where this will go yet, but it should be on everyone's radar.
Yeah, so more to come there. And if you're wondering why the FTC is chiming in there, it's because ultimately this impacts interstate commerce over which they have jurisdiction and say. So with that, that was a fast 30 minutes. So that's going to conclude today's discussion. Any comments in the chat will follow up with you. This webinar, as a reminder, was recorded and it's going to be available to view in our library on Thompson Hine's YouTube channel. So make sure you visit that page, like, subscribe, and hit that bell so you can get the updates as they come through. We want to thank you naturally for attending today's program, and a special thank you to you, Anthony, for all of your insight and knowledge. We're always so grateful to have you here and provide us with some really great information. So next month, it looks like we're chatting about cryptocurrency, which is always a hot button item, especially with the FTX fallout and all of that unfolding. So be sure to sign up for that as well, because cryptocurrency is still alive, albeit The Walking Dead in some respects, in different ways. So this is going to conclude today's webinar. Anthony, thank you so much. And I hope everyone enjoys the rest of their day and stay well. We'll see you next month.